argument. Attorney Fewer, how do you pronounce your last name?
It's pronounced foyer.
Foyer.
Like the foyer of a house.
Thank you.
Sure.
All right, we are now live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. With me this morning are Justices Henry, Justice Singh, and I'm Gabrielle Wolohojian. We're conducting this argument in this format due to the ongoing pandemic. Although we are conducting it in this format, all the ordinary rules of argument apply, including that each side gets 15 minutes to argue with no rebuttal. And with that, I'm going to call the case of Ryan Rodriguez-NAVARRO versus David Burgess and another, case number 2019 P1542. And Attorney Foyer, we're ready whenever you are.
Thank you, Your Honors. Good morning, Your Honors. This childhood lead poisoning case was dismissed on a 12B6 motion when the housing court judge wrongfully ruled as a matter of law that a lead inspector does not owe any duty to young, vulnerable children who live in the dwelling being inspected, does not owe a duty to conduct an accurate inspection for the presence of dangerous levels of lead. The judge made this ruling despite her explicit acknowledgement in her ruling that the, quote, purpose of accurate lead inspections is to ensure safe living environments for children under 6. That's at page 46 of the addendum to my brief. That's also the codified public policy of our Commonwealth. The ruling was also in contravention of the well-recognized tort duty to protect people who are foreseeably exposed to danger and injury as a result of negligence in performing a contractual obligation, which has been part of Massachusetts law since at least 1937 and was most recently affirmed in LeBlanc versus Logan Hilton, 463 Mass 316, a 2012 case.
Would you agree that there is no contract between your client and the defendant here?
Absolutely, Your Honor.
So we're not going to be looking to contract theories in order to answer the question as to whether there was a duty. Is that correct?
That's correct, Your Honor. We're looking at negligence in the performance of a contractual obligation.
Right. Now, the contractual obligation, as I understand it, was to whoever hired the defendant.
Yes, Your Honor, but there's also a tort duty there, as was stated in the LeBlanc case in 2012. And it's a duty in tort to protect and to be liable to people who are not parties to the contract, who are foreseeably exposed to danger and injured as a result of a negligent failure to carry out a contractual obligation.
So do you think that the question here then is whether your complaint alleged sufficient facts to state a claim that it was foreseeable that your client would be injured by any negligence of the defendant?
Yes, Your Honor.
All right, so why don't you point us to the allegations in your complaint that actually, well, first of all, frankly, I didn't see any allegations regarding foreseeability or what supported foreseeability. I didn't even see any allegations as to duty.
Thank you, Your Honor. This is on page 8, page 2 of the complaint. Paragraph 9, under the factual allegations, the inspection was conducted by the defendant, David Burgess, in 1993 was incomplete and inaccurate.
Yes,
The
but that
next
doesn't
paragraph
say
says, that the owner of the property who rented to my clients relied on the results of that, as they're actually permitted to do under the Massachusetts statutes for lead poisoning. General Laws, Chapter 111, Section 197, subparagraph C, says that premises for which a letter of compliance has been issued prior to January 1st of 1994 shall be deemed to be in full compliance with the provisions of the lead poisoning prevention statute. So he's entitled to rely on that. And then the next one is, as a result of and in reliance on the acts and failures to act of the defendant, the minor plaintiffs were rented this property, even though it contained dangerous and illegal levels of lead, which the defendants had failed to discover, had failed to document, and in fact, issued a letter of compliance specifically stating that the property did not contain dangerous levels of lead. That letter says—
where in the, excuse me, the letter is not attached to your complaint. Can you tell me where in your complaint you allege that the defendant owed a duty to your client?
I don't believe that we specifically used that word, but we did say in paragraph 14 of the complaint that the defendant was required to perform his duties with due care. He negligently issued this letter of compliance. As a result of issuing that, my clients were rented an apartment that had dangerous levels of lead, and my client got poisoned.
Sure.
It is notice pleading.
Yeah, but you still need to, I think, allege the elements necessary to support the claim. The owner who rented to your client was not the person who contracted with the defendant. Is that correct?
That's correct, Your Honor.
The complaint does not make that clear, I don't think.
No, there was, you're correct, Your Honor. There was an error in the complaint, but we've acknowledged that in the brief.
Okay, and complaint does not make clear how many intervening owners there were.
You're correct, Your Honor, because that's irrelevant. Every owner, after the one who had the lead inspection done, is entitled by statute to rely on the letter of compliance that was issued. In fact, the statutes also require the owner—
Which section is that?
That is Chapter 111, Section 197, subparagraph C, the 9th paragraph in that, which—
111, which one? Sorry.
Section 197, parentheses C, and then the 9th paragraph under subsection C. And in addition, Your Honor,
I just want to see if I can find that and follow along so I can see the exact language you're relying on.
Sure. It is in our appendix.
I see that.
And it's the paragraph that begins, premises for which a letter of compliance has been issued prior to January 1st, 1994.
Okay.
Do you see that, Your Honor?
Sure.
And that paragraph says, at the end of it, the last sentence, owners of such premises that have been inspected and issued a letter of compliance shall not be required to comply with any additional requirements of this subsection or of rules and regulations promulgated. So the letter of compliance also has to be supplied to people who buy the property. And we cite the statute for that as well, Your Honor. And once you get that, the new owner, any new owner, is entitled to rely on that letter of compliance. And the letter of compliance specifically said.
And in your view, it doesn't matter how long in the future that occurs. 100 years after the original letter, 100 years after the original letter, the duty still rests with the original inspector to every subsequent owner. Do you have a case that says that regardless of the passage of time, the duty of the inspector continues to any future owners?
No, Your Honor, we don't have a case that says that. But the reason for that is that after 1978, it has been illegal to add any lead paint to a property. And the law says that we're entitled to assume that people obey the law and don't add lead paint.
I think
it is. I'm sorry. Go ahead, Your
Honor. But there may be, as I understand it, you can get a letter of compliance even though there is lead paint there, as long as the lead paint is not exposed. Is that correct?
No, Your Honor. The lead paint, a violation of the lead statute can occur in two different ways. And the one that we're talking about is the presence, the actual presence of lead paint on accessible or mouthable surfaces. No matter what the condition of the paint is on those surfaces, that's a violation of the statute and the lead paint regulations. That was true in 1993 when the inspection was done, and we've cited the regulations to that and supplied the regulations. It was true in 2017. The same regulations applied then. The second way there can be a violation is if there is lead paint elsewhere other than on those surfaces that becomes cracked, chipped, or peeling. But that's not the issue here. The issue here is the presence of lead paint, the presence of it on accessible, mouthable surfaces. And
Counsel,
the letter,
can I ask you?
Go ahead.
Can I ask you?
I'm sorry, go ahead, Your Honor.
What is the effect? There were certain qualifications and limitations expressed by the inspector regarding the findings. What is the impact of those qualifications and limitations on this duty of care?
It requires other owners in the future to inspect for the condition of paint other than on accessible, mouthable surfaces. The letter stated that they had inspected the property for dangerous levels of lead, not for the condition of the paint, but for dangerous levels of lead that would be in violation of the lead poisoning regulations, and quote, determined that there were no violations. That means there is no presence of lead on accessible, mouthable surfaces. There may be lead on other surfaces, and if the paint there becomes cracked, chipped, or peeling, the lead inspector is not responsible for that, and the homeowner, the current homeowner, would be. So they have to look for those surfaces. But what happened in this case is, in 2017, a second inspection was done by the Massachusetts Department of Public Health, and they discovered at least 8 accessible, mouthable surfaces that had dangerous levels of lead that were illegal to have, that the first inspector had said didn't exist. He said there were no violations. So it's the presence of lead that is the issue here with the lead inspector.
So on these surfaces that are accessible and mouthable, can those be encapsulated and then get a compliance letter?
They could be after the regulations were changed much later than 1993. Those regulations allowing encapsulation occurred much later. The original ones said you had to remove them. You had to remove the lead that was on accessible, mouthable surfaces.
And so what you're saying is that on those surfaces at the time that this 1993 letter was issued, that those had to be, those could not be encapsulated, they had to be removed.
Correct, Your Honor.
And what's the citation for that? You indicated that this is in the records. I want to make sure we know exactly where you think this is.
Yes, Your Honor. Hang on one second. Let me look at the, it's in our brief. It's part of the addendum to the our original brief. And sorry, Your
And
Honor.
I do have, that's okay, take your time. I do have 2 more questions that I hope are quick.
Yeah, it's on pages 48 through 54 of the addendum to our original brief. Those are the regulations that were in effect.
And is there a particular place in those 6 or 7 pages?
I don't think those are the right pages. I'm looking, that's chapter 93A, if I'm correct, if I'm looking at the right thing.
He's in the addendum to his brief, not the record appendix.
I'm in his brief.
Okay.
It should be page 48. It should be chapter 111, section 94. Oh, and then there should be the regulations. Should be in there as well. It may be in the appendix.
I think the regulations begin on page 69.
I'm sorry, Your Honor, you're correct. I apologize.
Is there a particular regulation you want us to look at?
Yes, Your Honor. Let's see. You're looking at the record appendix, Your Honor.
I'm looking at the addendum to your brief.
We're looking at the 1988 CMR, and it seems like you're trying to tell us in the 6 or 7 pages there's some particular provision, and we're reasonably smart, but I'd rather you tell us exactly what you want us to look at.
It's looking at page 25 of my reply brief.
Oh, your reply brief.
Yeah. So where it defines dangerous levels of lead on page 25. And on where it defines accessible, mouthable surfaces.
And is this the regulation that was in effect at the time of the inspection or some other time?
This was the regulation that was in effect in 1992 and was in effect when the inspection was done in 93.
All right.
Can I just
Henry? Yes, of course.
the defendant says that this initial 1993 compliance letter was not revoked by the Commonwealth, but the Commonwealth issued its certification of restored compliance. So what do you say to that?
I don't understand how that's relevant to this. The letter of restored compliance had to do with the cracked, chipped, and peeling surfaces, and had to do with what was done after my clients were lead poisoned, and after the second inspection in 2017. It has nothing to do with the fact that my clients were renting an apartment that had contained dangerous levels of lead, the presence of them on accessible, mouthable surfaces. So
All right.
it's irrelevant to our claim.
Justice Henry?
I'm set.
I have one further question. Why is the landlord who rented to your client not an indispensable party?
He is one of the parties who could be sued under this, but a letter of compliance under Chapter 111, Section 197C would provide him with a complete defense to this. He's entitled to rely on it, it said, and he's not required to comply with any further actions here. So suing him would be a waste of time, Your Honor. We can't,
I'll
get
throw
past the
something
letter of
out there.
compliance.
If
I'm
the
sorry,
if the regulations changed such that removal was no longer necessary, but encapsulation was enough, then perhaps reliance is a question of reasonableness. And in that, the owner's reliance on the previous letter was a question of reasonableness. Why, if that's true, why wouldn't the current owner be an indispensable party?
Because there was no reason for the current owner to do a full lead inspection to find stuff on accessible, mouthable surfaces. He's entitled statutorily to rely on that previous letter. It says owners shall not be required to comply with any additional requirements like encapsulation or anything else that happened. Premises for which a letter of compliance has been issued shall be deemed to be in full compliance. So he was entitled to rely on that. And it seemed to us that it would be a waste of time, futile to sue him for that. The defense is right in the statute.
All right, I think we have your argument and your time has expired.
Thank you, Your Honor.
We'll now hear from Attorney Trapani.
Good morning, Your Honors. I represent the defendants in this action, and I would start with the premise, or just the premise that this is positive as a negligence claim against my client, and there is a 93A claim that I would like to talk about at the end as well. But with respect to a negligence claim, we do look to those normal tenets of negligence: duty, breach, harm, causation. And here, the duty is very much defined by the statute. It created the duty, but it created it for the legislature decided to create this duty as to an owner, to a tenant, and specifically a tenant under 6 who's not only either residing at the property, but will imminently reside at the property. That duty doesn't arise till then. And so stating that my client writing a report in April 1993 has a duty to somebody who doesn't become a tenant until May 2015, while in the chain of events under the law that your court and the SJ and the Supreme Judicial Court has stated for foreseeability, yes, my client did write something in 1993, and they're saying they relied on it and presented it to somebody in 2015.
Yeah, but counsel, the date is a happenstance. In other words, a child could have moved in the very next year. And so it could have been a year, 2 years, 5 years, or in this case, like 22 years. But if the letter said that there was not lead on these mouthable surfaces when there was, and at a time when encapsulation was not sufficient, then why does that not create a duty? Because the time is just a random event.
Well, the legislature has decided, I think that it needs to be read, because the legislature also said that there's strict liability for owners that do not have this letter, but they still allow for a negligence claim even when a letter of full compliance exists. And that's why I think that my brother's argument that this is a complete bar for owner liability is incorrect.
Which statutory sections are you referring to when you say the legislature has decided things?
Well, decide 197 that was cited previously that goes towards what must be done and who must do it. And then 199, which creates the cause of action and how one can be liable. And just relying on, I'm sorry, the name just went up and I'm going to turn, the case law specifically, and I'm going to mispronounce it, Androwitz, that I rely on in my brief. And I think even, Your Honor,
So can we look at the specific statutory language you're relying on?
yes, Your Honor.
That would be helpful.
I
So
apologize.
You're looking at section 199.
Yes.
Is there anything in 197? Because you mentioned that too.
Attorney Trapani, you've gone on mute.
Thank you. I would, 111, 197 requires the owner to take affirmative measures. Let me just tell you exactly where that is. And I was quoting from Mr. Fowler's brief on page 27, where he's citing to, I believe it's 372 Mass 631, where the SJC says that section 197 states that owners, but the statute requires the owner to take affirmative measures. Sorry, I'm not finding the exact part where he says that. Bear with me, Your Honors. I'm sorry, I just can't find exactly where in 197, whether it's B or whether it's in C.
All right, and 199?
And 199, Your Honor, which creates the cause of action. And specifically in the cause of action, Your Honor, it discusses if there's a letter of compliance, there's no, where there's no letter of compliance, there's strict liability that's applied. Where there is a letter of compliance, then the owner may still be liable to the tenant if they do not, unless they show reasonable care in what they were doing. And the Almonte case, which I can cite to, was from this court, 2012 Mass App. It was a December 2012 decision. Did discuss, and it was a motion for summary judgment. It affirmed the motion for summary judgment where somebody coincidentally had a 1993 letter of compliance. They then were sued for lead paint liability to a child tenant, and summary judgment was affirmed not because they had the letter, which Mr. Fowler would suggest, but because they engaged in reasonable care of the property. They did annual inspections to make sure that the property was maintained and in compliance with that qualifying language that we see routinely in these letters of compliance, which is that you maintain the paint from painting, chipping, and so forth, but also coverings, Your Honor. Because there can be coverings over things that don't allow you to get to the lead paint. And I think—
No, but counsel, he says that back in 1993, that you couldn't encapsulate a mouthable accessible service. Do you think he's reading the rules wrong?
No, Your Honor, I did not see that he's reading that rule wrong. I see the change. I guess the nuance that I would say is we don't know what the status of those accessible mouthable surfaces was in 1993. There were 5 owners in between when my client was engaged to do this work and when Mr. Warren took ownership of the property and then had it for 8 years. We don't know if those things were covered in such a way that they wouldn't have even been accessible to the tester. And that's why I think the onus is put on owners, because they're in control of this property. They're the ones that can change it. And when they do work on the property, or they're inspecting their property, they're doing it with the language of these letters of compliance in mind. And they may have to bring it back into compliance as the statute suggests, even if it's to a pre-existing regulation under the 1994 date that Mr. Fowler referenced.
So, go ahead, Justice Wolohojian.
I wanted to go back to Justice Henry's original question and maybe just state it in a different way. But you would agree that if your client performed an inaccurate inspection negligently, let's say, in 1993, he would owe a duty to the then current owner and any tenants under the age of 6 at that time.
He would have a duty to that owner, yes. The child under 6, again, I'm not sure that case law has read the statute to mean that, but yes, I would agree to, the case law definitely says the owner.
Okay, so let's assume it extends to the child who's directly harmed as well. And how long then does that duty last?
Well, here, let's just take Mr. Warren, for example. So he owns this property, he gets it in 2007. He takes our letter. Mr. Fowler's co-counsel in the trial, in the housing court, submitted an affidavit that was considered by the court that said, I took the letter, and I'm paraphrasing, Your Honor. I took the letter and I presented it to tenants, and they relied on it, and I relied on it. Except that's in direct contravention to what the statute actually requires, because with that letter of compliance, he still has to make sure that the property is in compliance with the letter of compliance. Sorry to use that word so many times, but that again, the coverings that existed back when this was done in 1993 still exist. That yes, the flaking issues and stuff like that aren't present.
I'm trying to figure out if what you're saying is that the passage of time makes a difference or the change in ownership. If it were the same, if there hadn't been a change in ownership and this was the same owner with whom your client had contracted, but 22 years later, would that owner be entitled to rely on the letter?
If they acted reasonably, as in the case that I mentioned, the Almonte case earlier, where not only do you have that letter, but then you can track back from the date that you're presenting that to your tenant to the date of that letter that you have taken reasonable action to ensure that the property has been maintained in compliance with that letter. And that's what, because that letter is so qualified. And unfortunately here, I think that's harder to do for the plaintiffs because there were so many changes in ownership. But
well, so I don't hear you necessarily articulating a bright rule of law that terminates your liability either on a change of ownership or after the passage of time, but rather on whether owners acted reasonably.
I think that, as Judge Fine found in the housing court, if a letter becomes stale, and this is by the time it was presented to this tenant, it was a 22-year-old letter, and this owner himself had it in his hand for, I believe, 8 years when he presented it. I think that there can come a time when you can't rely on that letter because it has become so stale, and normal maintenance of the property would require some action in order to be found reasonable and to avoid any liability.
So are you saying that the plaintiff has an affirmative duty to allege in their complaint their own reasonable, no, I'm sorry, not them.
The owner's reasonable.
Yeah, the owner's reasonable reasonable conduct over time.
Well, the plaintiffs would say that it was unreasonable, that they didn't, that despite so because they have the letter, the plaintiffs are going to have to prove that with the letter, the owners still acted unreasonably and that they did not maintain the premises in order to keep it compliant with the lead law requirements.
That's it, to the owner, right?
That's as to the owner, but the lead paint law does contemplate either strict liability or a negligence claim, and what must be proven in a negligence claim. And the owner the owner is solely liable to the plaintiff. Now, the plaintiff can bring other claims such as breach of implied warranty of habitability, quiet enjoyment, and even a 93A claim where based upon the Attorney General's regulations for tenancies. But
your client bring the owner in?
Well, we didn't, just because we didn't get to that point. But that's why I named them as an indispensable party, or I moved on the grounds of Rule 19, that they were an indispensable party. I think the argument, Your Honor, would be that the plaintiff would have to prove that the owner that the owner was liable to the defendant before bringing a claim against us, because in all other claims where someone other than the owner has been brought in for liability purposes, it's either been on a contractual obligation, which doesn't exist here. I think I would surmise that under the contribution statute, you could have an assignment by the owner under 230.
Because there's no contractual relationship, aren't we in a situation where the whole point of this system is it's foreseeable that a child would be harmed? And if your client said there's no lead in a place where there was definitely lead, forget encapsulation because that hasn't happened yet, how is it not foreseeable that any child that comes to live in the apartment or perhaps visit for an extended time that would be injured?
Well, because then that creates a duty in perpetuity. So a child could come into there at any time, where the statute is, I think, pretty specific, and the SJC has been specific that the duty doesn't arise until the tenant lives there or is imminently going to live there, such as they've signed some sort of binder. That creates, again, liability in perpetuity that I don't think has been recognized at any time. That's why foreseeability has put limits on things, such as even in the Levitt v. Brockton Hospital case that I cited to. I'm not sure if that answers your question, but the other part is I want to separate between encapsulation and something that was merely covered, because again, the owner is in possession of these premises and the tenants are in possession of these premises, and they're the ones that know whether there was anything changed. And I hate to bring up personal analogies, but I've never lived in a house that was built after 1910. And I've lived in Dorchester, and I've lived in Leeds, and I've lived in Florence. I have lived in homes that have literally new trim around old trim to prevent you from getting to the lead-based trim. What I'm saying is there can be moments where something's covered, something that is accessible and mouthable is covered by something else, and then that's changed.
Right, but that's what I'm trying to get at, and what I would really prefer you tell us rather than you both leaving us to figure it out on our own, which is where I'm feeling we are right now, which is that Attorney Foyer has told us that in 1993, that for accessible mouthable surfaces, you could not cover or encapsulate at that time, that it had to be entirely removed. I don't know whether he's right. If he's right about that, then any letter that was issued before the encapsulation could create this liability in perpetuity. If you tell me he's right about that, that's one thing. If you tell me he's wrong, that's another thing. But I thought you told us earlier he's right.
Yes, I can't disagree that the regulation said what it did, but what I'm differentiating between something that is encapsulated as a remedy versus something that's covered at the time of the inspection.
Such that the lead inspector could not get to it.
Yes, there's a difference there. And the letter specifically contemplates that because it says, as long as coverings forming an effective barrier over such paint and materials remain in place. There might be times where you couldn't test something because they were under something else. And there isn't a duty, and I've never, the same regs, and I've read them, doesn't have someone digging under layers and layers of materials. The owner is in the best position, and that's why the statute, I think, is drafted as it is, to know what changes are made and to become concerned about that and have a duty of reasonable care to then get exactly what happened here, a certificate of restored compliance, if changes are made or deterioration occurs.
Okay, we're gonna have to leave it there. Your time has expired, but thank you both. It's a very interesting case and we've been helped by both of your arguments. The case is submitted.
Thank you, Your Honor.
All right, we're live and recording.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we're conducting court in this fashion, all the ordinary rules of argument apply as though we were in our courtroom, and that includes that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of CARNAKIE-BROWN versus Santander Bank, case number 2020P0295. And Attorney Ackerstein, we're ready whenever you are.
Thank you. May it please the court, Michael Ackerstein, counsel for plaintiff appellant SURAYA CARNAKIE-BROWN. Before this court is plaintiff's appeal of the Superior Court's award of summary judgment to defendants as to plaintiff's claims of discrimination and retaliation. Plaintiff's claims stem from her termination by her employer defendants after she complained both internally and externally about discrimination. Plaintiff's written submissions demonstrate that applying the relevant standards set forth in Bulwer and considering the relevant facts, law, and inferences, summary judgment is inappropriate as to plaintiff's claims of discrimination and retaliation.
So,
Recognizing.
Your client does not dispute that she violated the bank's cash handling policy, right?
Plaintiff doesn't dispute that she left cash unsecured for about 20 minutes. She does dispute the description of her violation and the disparate treatment afforded to her in connection with that violation.
I understand that, but she did violate a policy about leaving cash unsecured, correct?
That's correct, Your Honor.
And there were, and I'm now going to divide between two periods of time. In the written warning, there were customer complaints about her. She doesn't dispute that either, right?
She doesn't dispute that there were customer complaints about her in the final written warning that was issued in June 2017, Your Honor.
And she doesn't dispute that she fell asleep in the conference room where people could see her, like a glass conference room.
She's not disputing that either, Your Honor.
And I know there's some issues about the timing, but she also left early to go shopping one day.
There are disputes about the timing, but otherwise you're correct, Your Honor.
Okay. And now shifting to the later period where there's this issue about pretext and whether there's a factual dispute on pretext. I understand the bank answered an interrogatory about why it terminated her employment, and then during the litigation seems to have added a reason about the anti-money laundering, right?
Yes, Your Honor, not just added a reason, added the reason, added the last straw, to use defendant's language.
Right, but she doesn't dispute she missed the money laundering deadline.
Well, the characterization of what happened with the money laundering deadline is in dispute.
Can you explain that?
Sure. Defendants allege that she missed a deadline and ignored it and was unapologetic for it. Plaintiff's position is she reached out to a customer that had a non-working phone number and also reached out to the customer via email. So the circumstances that she ignored it and was unapologetic about it is disputed.
All right. And you cite only a Superior Court case. I'm changing gears here just to warn you. You cite only a Superior Court case for the proposition that complaints by other employees about the supervisor having racial animus are relevant, in the case at bar. Do you have a case from our court or from the Supreme Judicial Court on that point?
As to that point, Your Honor, the case in our brief is the only case we're offering it. So I recognize certainly the panel's familiar with our written.
Sorry, given the lack of dispute over certain performance issues, how do you get over the threshold of a prima facie case?
Well, I assume the question is the plaintiff's claim of discrimination, Your Honor.
Yes, and that she was performing her job adequately.
Yes, Your Honor. As articulated in our briefs and as recognized by the Superior Court, in September 2017, so this is now several months into her employment. This is after she's complained internally about discrimination and right before she complains to the MCAD. Her branch gets a 90% customer satisfaction score, which is well above the average. Additionally, Your Honor, as contained in our briefs, there's testimony from her colleague, Allison Sampson, about how well the plaintiff was doing in the branch and about how well the branch was doing. As noted in our briefs, Your Honor, in defendant's interrogatories, that employee, Allison Sampson, is identified as someone who has knowledge about plaintiff's performance and conduct as branch manager. So
after the final written warning?
Ms. Sampson's testimony and the 90% customer satisfaction score are both after the final written warning, Your Honor.
Okay, so are you basing the discrimination claim on the written warning?
Well, the discrimination claim, Your Honor, is that plaintiff is alleging she's no longer working there because of her race and because of her national origin. And as evidence for that, she cites a pattern of events that begin with disparate treatment as compared to a white comparator, the same white comparator who ultimately replaced her without considering any minority candidates.
Okay, but I'm trying to get a handle on the timing. Do you think that her race or minority status were the reasons for sending the final written warning?
That is plaintiff's, that's plaintiff's allegation in this case, and that's what she alleged in shortly thereafter when the final written warning was.
Okay, and so what is the evidence of discriminatory animus as of that date?
The evidence of discriminatory animus as to the June 2019 written warning is the treatments of plaintiff's colleague, who was also Black and Cape Verdean. We allege the comments made. It's not just that Ms. Nelson had commented on the Black Cape Verdean employee's hair. It's that she did it when the employee had dreadlocks. It's not that she commented on the entire, it's that when she came in wearing a dress. And so that's the discriminatory animus underlying plaintiff's initial complaint of discrimination. In addition, plaintiff's initial complaint of discrimination, the internal complaint, alleges disparate treatment as to the incident with the currency cash policy, where both she and her white comparator left money unsecured in plaintiff's case for 20 minutes, in the comparator's case for an unknown amount of time, in addition to a pattern of disparate treatment as to the Cape Verdean colleague as well.
Okay, and what was the evidence that she was performing her job adequately as of the time of the final written warning?
Well, adequately in terms of establishing a
prima facie case.
Yeah, adequately in terms of establishing a prima facie case is the fact that it's not disputed that defendant didn't have cause to terminate her in June 2019. They considered whether or not she was going to be terminated, and they determined they didn't have cause to terminate her. So the fact that they considered it and affirmatively rejected cause to terminate is indicia that she was performing at least sufficient to meet the standard.
I have to say that logic sort of escapes me.
Well,
She wasn't terminated. She was given a written warning, which is clear that they thought she deserved a written warning.
well,
So
perhaps,
what is the evidence that she was performing her job in a way that would have not been in order?
well, the evidence that a written warning wasn't in order, or a final written wasn't in order, is that the determinative event for a final written warning is the violation of the currency cash order policy, which merely warranted a coaching for the white American-born comparator. The two employees engaged in reasonably similar conduct. One is awarded a final written warning, and the testimony from Heather Nelson is, I thought it was a terminable offense. And as it pertains to the white comparator employee, it was deemed a breach of protocol warranting a coaching, but nothing more. So to the extent Your Honor is asking, how do we know that she was performing acceptably? Well, her colleague wasn't given a final written warning. So that's evidence that the perception of performance, had it not been a discriminatorily or disparately applied policy, would have been sufficient.
As I understand the bank policy, but correct me if I'm wrong, there's a person who is, when the money comes into the bank, there's a person who, in essence, accepts it and becomes responsible for it. And there then has to secure it according to the protocols. And in this case, that was your client. Is that correct?
Yes, Your Honor. I think your understanding of the policy is correct, but I think it goes a step further than that.
All right, so you're gonna have to show us where the written policy, where it goes further.
Well, certainly, Your Honor. As it pertains to the policy, it's in the policy. It's Record Appendix 2, page 131. There are two references to making sure cash is secured, and Your Honor, I'm not disputing that your understanding is. I recognize your understanding is correct, but plaintiff's point would be, the issue is the point of the policy is to make sure cash is secured. The person who puts it there is the person initially responsible for securing it, but there are two references on that page to securing cash. And so the issue is cash secured? The plaintiff, for a period of 20 minutes, left cash unsecured. The white American-born comparator employee realized cash was unsecured, and instead of making sure cash was secured, again, referenced twice in the policy, says, I'm going to leave it here, and I'm going to see what plaintiff does about it. Also leaving the cash unsecured. Your Honor, the record doesn't show how long that employee left the cash unsecured, because Ms. Nelson decided it wasn't relevant to look into it any further. She just says this is a fireable offense from the plaintiff, and this is a coaching from Shauna Moore and Lee Green, who's the white American-born comparator. And this is relevant, Your Honor, because recognizing defendant's position as to plaintiff's job performance, which again is in dispute, especially in light of the fact of the 90% customer satisfaction score and the positive testimony. The question at summary judgment is, could a reasonable jury infer that the performance issues were not the real reason for termination and that they were pretext for something else? The disparate treatment between plaintiff and Shauna Moore and Lee Green is just one example of the significant amount of pretext in this case that would permit a jury to infer that the reasons being offered are pretextual. Shauna Moore and Lee Green is treated differently. Shortly thereafter, the plaintiff complains about discrimination, and defendant conducts this sham investigation, the results of which are revealed beforehand. Plaintiff turns the branch around, and nonetheless is subject to a vigorous pursuit of termination after defendants become concerned she's going to file a lawsuit. Plaintiff files a charge of discrimination with the MCAD, and Heather Nelson stops passing on positive information about her up the chain. And then shortly after she's filed at the MCAD, there's a purported last straw, which is in dispute and not even raised in the interrogatories that justified termination for lack of trust. So, Your Honor, as to your initial question about the currency cash policy, it's not disputed the plaintiff violated the policy, but what's at issue is that Shauna Moore and Lee Green also violated the policy, was treated disparately, and that's just one example of the evidence of pretext that makes summary judgment inappropriate. It should be left to a jury to determine whether or not the performance and not these significant examples of pretext were the real reasons.
So counsel, changing gears to the retaliation claim, what's the specific act of retaliation? Is it the termination?
Yes, Your Honor.
Is there any other act of retaliation?
Well, the adverse employment action suffered is termination. As evidence of retaliatory animus, which goes to a finding of pretext, plaintiff offers that there's plenty of it. Plaintiff complains about discrimination in June 2019. Ms. Nelson's testimony is that she believed it was motivated by ill will and retaliatory, and she creates a special folder to start tracking plaintiff on her computer. Ms. Nelson had the opportunity to testify as to whether or not there was anyone else of the 130 employees that she was doing that for, and the answer was there wasn't. She couldn't identify anyone else. Plaintiff is considered to be contemplating litigation. There's an allegation that she has a plan, and then Ms. Nelson starts pursuing vigorous pursuit of termination. So, Your Honor, as to your question, you're right, the termination is the adverse action at issue, but the ongoing connection between plaintiff engaging in protected activity and being targeted goes to show retaliatory animus, which is relevant to plaintiff's argument that there's sufficient pretext here that a jury can infer it was retaliation.
What I'm trying to find, though, is what's the limiting principle here where you have an employee with clear performance problems? The bank says, well, your argument basically closed this person in immunity and that we can't have that. So how do we set some sort of reasonable boundary here? Because if you can't have a poorly performing employee just be protected because they claimed discrimination.
No, and that's not what plaintiff's argument is, Your Honor.
So what's the line?
Well, the line is in September 2017, September 29, 2017, she's got a 90% customer satisfaction score, and she's got her colleague testifying how well she's doing. It's a week later, it's the first week of August, the first week of October, that she files her charge at the MCAD. And so if the concern is, well, couldn't any employee who's about to be fired just go file a charge and close themselves immunity? I'd say, Your Honor, that's not what's happening here. She was doing great at the end of September. At the very least, there's a dispute as to whether or not she was doing great in September, but there's certainly evidence that she was. And that's when she filed a charge at the MCAD. And then she continues to do well. And we've pointed to the success stories. Those aren't passed up the ladder, just the negative stuff. And then she's terminated for lack of trust. She files a lawsuit. We get interrogatories. There's no mention of the AML. And finally, defendants move for summary judgment. And then for the first time, there's an affidavit from Ms. Nelson saying, well, there was another issue that came up thereafter.
All right, I'll have to leave it there. Your time has expired. Thank you.
Thank you.
Attorney Santos.
Good morning, Your Honors. The Superior Court properly awarded summary judgment here, and the decision is well grounded on the factual record and on the standards set forth in Bulwer and Verdreger and all of the cases that follow. Appellant claims that the Superior Court ignored the pretext standard from Bulwer, but that's just not true. Bulwer is cited throughout the decision, and the court grounds its findings on the Bulwer pretext standard.
But counsel, the plaintiff made an argument with some force that the Superior Court applied the wrong standard in citing Bruce. And I didn't really see a response to that in your brief.
So the court actually, if you look at the pretext analysis in the decision, relies very heavily on Bulwer. And I think it's really important to look at the difference between Bulwer, Verdreger, and this case. The key difference between these cases is the undisputed performance record, the questions that you were just honing in on. Because in this case, unlike in Bulwer and unlike in Verdreger, there is a clear documented record of terrible performance issues over a short period of time. In Bulwer, you have supervisors providing good feedback and negative feedback. You have questions about the performance issues at hand. You have serious material disputes about whether there are performance issues. And that's what guides the pretext discussion.
I just want to stick on the Bruce point for a minute. Is Bruce still good law?
Well, I think Bruce has been qualified by Bulwer, and I think that anyone who's litigating employment disputes today does look to Bulwer for the pretext standard. It's true, we exist in a pretext-only jurisdiction. And I believe here that the performance record sufficiently establishes no question of material dispute around Ms. Carnakie-Brown's performance record. If you look at her deposition.
But his response back to that is there are a couple of responses, actually. The first question I have is on this question of comparator, because we do have these two people who left money unsecured in the vault, right? Because isn't the point to prevent money from being stolen?
So the Superior Court absolutely got the analysis of Ms. Green right. There are sort of both factual and legal inaccuracies in appellant's argument here. First,
before we get to that, I want to understand whether the standard here is a legal question or is it a factual question, whether somebody's a comparator.
Absolutely. So Matthews versus Ocean Spray, the SJC case, sets the threshold legal question that must be answered before a case can proceed to a jury on a comparator issue. And that case says that we need to be comparing apples to apples. The comparator needs to have similar conduct, similar qualifications, similar background. Here we have very, very different circumstances. Ms. Carnakie-Brown, in her deposition testimony, admits to taking possession of the cash, signing off on $123,000. She admits to just dropping it on the floor of the vault. Ms. Green discovers the violation, escalates it to her manager, who says to secure the cash. An employee who merely discovers the violation isn't violating the policy.
I thought there was some interim period where Ms. Green did not escalate while she was waiting to see if somebody stole the money.
The way she communicated it was, I'm waiting to see if it should be secured. She didn't violate the policy. The policy is that the person who accepts and signs for the money must secure it under dual processing.
No, I understand that, but in terms of, the point is that you don't want the money stolen, right?
That's right.
And both of them left the money in a position where someone could steal it, didn't they?
And Justice Henry, to that I say two things. Ms. Green was coached about not immediately securing the money, and that is commensurate with the violation. She escalated it to her supervisor without immediately securing the cash. Second, Ms. Carnakie-Brown had a number of other performance issues that supported the final written warning. I mean, Ms. Green did not have 6 customer complaints accrued against her over the course of 3 months. Ms. Green had not fallen asleep in a conference room.
I think Judge Wolohojian's trying to get in here. Judge Wolohojian, you're having a slight delay. Just so you know.
Okay. What I understand you saying is you acknowledge that both employees may have a real world practical responsibility to secure cash in the bank, but that the policy placed there was policy responsibility. The bank had a policy that placed responsibility on the person who received the cash.
That's right. So the cash orders policy, on which they were all trained, requires that the person who signs for the cash immediately secure it under dual control. Okay. And that's where, if you look at the testimony, it wasn't complied with. And she admits that she didn't comply with that policy.
All right. And that was not a responsibility that rested with the coworker.
That's right. And so to continue, Ms. Green just didn't have all of the other performance issues that Ms. Carnakie-Brown had been encountering at that time. The customer complaints. Ms. Green hadn't fallen asleep in a conference room. She hadn't closed her door to work on personal matters on a busy day at the bank.
All right.
So they simply weren't similarly situated.
Here's then, because there's a lot of material in this case. I want to have you help us get through it.
Sure.
I see an interrogatory response from the bank that explains why they terminated the plaintiff. I don't see that the violation of the anti-money laundering situation listed in that answer.
I don't believe that the bank limits itself in that interrogatory answer. As if it sounds like you've reviewed it, it begins with Ms. Carnakie-Brown was terminated for a long track record of poor performance issues, and then proceeds to offer a number of different examples. Now, there were 4 to 5 complaints that came in over September, October, and early November, followed by the anti-money laundering email, and all of those things sort of precipitated. This is a drip, drip, drip case where there were an accumulated number of different instances, both small and large. And to focus only on the anti-money laundering as saying, well, how could this be the cause of the termination, ignores that this is just one more thing on a whole host of different performance issues that it's stacked up against.
You
Ms.
agree
Carnegie-Brown.
that particular drip is not in this answer?
It does not appear in the answer, and I don't believe the answer limits itself. It's an interrogatory answer that outlines some but not all of the performance issues, and certainly doesn't state that it is limited to the ones that are listed in the answer.
Well, the interrogatory itself says provide a complete account.
Sure, and there are over 50 different performance issues in this case. The bank listed a number of the key ones right up to the complaints over September, October, and November. But it doesn't say that in its answer that these are the only issues that supported the termination decision. It clearly opens itself by saying it's the track record of performance issues here.
So after the final written warning, do you agree the question then becomes whether her performance was satisfactory or not?
So a couple things. First of all, I think it's really important to note that Ms. Nelson, her supervisor, wanted to terminate her before the complaint of discrimination. And I think that's important to both of her claims, because her claim is that Ms. Nelson is harboring both retaliatory and biased motives here. And just 6 months after hiring her, she's looking to fire her, and that's before her complaint of discrimination. And so this case is quite like Mesnick, where the plaintiff complained of age discrimination multiple times in his employment, and the timeline doesn't restart with each complaint. The court recognizes that the performance issues are predating that first complaint, and that this is just a long history of performance issues with complaints sort of interspersed throughout. So it's artificial and sort of disregarding that line of cases to say that we restart the timeline each time that she complains of discrimination, which is what appellant appears to be arguing here.
Well, maybe not that the timeline restarts, but that you have to, when you're looking at when they take adverse action, you have to look at that point in time, is it reasonable to be taking this adverse action when this person has rehabilitated themselves?
So absolutely. But I think you have to be really careful here, because she was on a final written warning, which is, it's the highest discipline short of termination. It says within the warning that further misconduct can lead to termination. She admitted in her deposition that she understood that. She admitted that in her complaint of discrimination, that she felt like one more thing would get her terminated. And that's factual. Ms. Nelson wanted to fire her before giving her that final written warning. So when 5 additional customer complaints come in, prompting Ms. Nelson to opine that she's never seen a single branch manager in her 33 years at the bank receive so many customer complaints. When 5 come in after that final written warning.
So I'm a little confused about that, because what was the bank's customer satisfaction rating in that branch prior to the plaintiff being the manager?
So the CSAT issue is really undeveloped in the record. There really isn't evidence that it was material. But I would say that, the smattering of issues that appellant points to in September, the CSAT score, and Ms. Sampson, a subordinate's opinion about how the bank was functioning, certainly doesn't undermine this long history of performance issues that she's struggling with.
But wasn't the branch's record significantly lower prior to the plaintiff becoming the manager?
Sure, and I would say evidence that the branch manager is doing her job is not sufficient to overwhelm the performance record here. This is not like Bulwer, where we have numerous supervisors providing glowingly positive reviews about the plaintiff. This is a case where a number of the performance issues are supported by third-party customers coming into other people. The complaint in August is to the Abington branch manager who sends an email to Ms. Nelson, attached to her affidavit in the second volume of the appendix. It says the worst part was that this was the branch manager and this issue has been going on for 2 months. So these customer complaints are coming in from all sources, not stemming solely from Ms. Nelson, who Ms. Carnegie-Brown is trying to paint as a biased manager. So she's continuing to accumulate all of these customer complaints. She makes an error on the bank vault timer, which causes money to be unavailable to the bank the next day. That's in August. And then the customer complaints continue to come in with the theme that she's just not following through. She's not responsive. People are unable to get their debit cards.
That's the question I don't understand, is how would, on a summary judgment record, we evaluate that? Because it seems like there is evidence that the 90% is a substantial improvement in the score of the bank, and that seems, rather than get enmeshed in subjective criteria, that seems like an objective criteria that even with some complaints that the branch is doing significantly better.
Justice Henry, that is a very good question. And, again, I would say the evidence that she was doing her job is not evidence that overwhelms the record here. And further, it's really an underdeveloped fact that doesn't really have support in the record, other than the fact that that Heather Nelson said, good job, Ms. Carnegie-Brown, for your 90% CSAT score in September. Now, there are a number of other very serious issues that she encountered before and after that issue that it's simply not insufficient to create a fact issue that proceeds to a jury.
So the plaintiff argues in her reply brief that as of September 20th, 2017, there were not grounds to terminate the plaintiff and no decision had been made to terminate the plaintiff on that date. What do you say to that?
Yeah, if you look at Ms. O'Donnell's affidavit in volume 2 of the record appendix, it is clear that she was being very careful here, right? Ms. Carnegie-Brown had been placed on a final written warning. She had complained of discrimination. Ms. O'Donnell sent an email to her supervisor outlining the entire history here in preparation for a meeting with her superiors because she wanted to be very careful here. She recognized the legal risk. It doesn't mean that there weren't grounds for termination at that point. It means that they were being cautious. They had a number of issues in August, and then multiple customer complaints come in after that meeting, followed by Ms. Carnegie-Brown blowing through the anti-money laundering deadline. Now, I understand that she's disputing, she's sort of quibbling with the details of that, but the email speaks for itself. It's attached to Ms. Nelson's affidavit. It shows the important deadline under the heading urgent being sent to her. You see no response. You see Ms. Nelson following up with her. All of that is undisputed in the email attached to Ms. Nelson's affidavit. So, in conclusion, I think that this case is really, it's distinguishable from the SJC decisions that find pretext, where you have a lot of mixed reviews about the plaintiff who's contesting the decision. Here you have a really undisputed record. If you dig into her deposition testimony, she largely admits to the majority of these performance issues, and the bank was well supported in its termination, and the Superior Court rightly found that we might not even need to get to the pretext issue because it's such a close question on whether she's even making out a prima facie case. Thank you.
Very much. It's an interesting case, and we've been helped by your argument, both of your arguments, and the case is submitted.
Thank you very much.
Thank you. Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting oral argument in this way, all the ordinary rules of argument apply, including that each side has 15 minutes to argue with no rebuttal. And with that, I'm going to call the case of Sunrise Equipment and Excavation, Inc. versus Construction Management and Building, Inc. Case number 2019 P0833 And Attorney Sullivan,
Yes, Your Honor.
we're ready whenever you are.
Yes, thank you, Your Honor, for hearing us and making yourselves available. I would like to begin the argument here with the issue that came up first in this case. And that would be the decision of Justice McGuire to vacate an entry of final judgment that occurred back in December of 2015, well before there had ever been a trial, but it was an interlocutory order. And so was not appealed at that time. Now, this motion was made after the entry of the judgment. There is no indication in the file, and never has been any indication in the file, that the judgment was not properly entered. The judgment was entered under Rule 33A as a result of the failure of the plaintiff to respond to interrogatories that were first propounded in August of 2015. And we went through the course of asking for a final demand for answers, nothing from the plaintiff's side. They were aware of it, as was noted in my objection and my memorandum that was filed when this hearing was held initially. They promised they'd file it, and they didn't. And now 33A requires at the end of the line that the answers actually be physically delivered. It's not a service requirement, and the answers undisputably were not delivered by December 2nd, which was the date they were due.
Let's assume for the moment that they violated their discovery obligation. Let's just assume that for purposes here. Is it not a discretionary, is it not within the discretion of the judge below to nonetheless vacate a default judgment?
The judge's discretion is limited by what the basis is. In this case, the motion wasn't filed as a 60B motion. It wasn't filed as anything in particular except as an emergency motion to strike. There was no reason at all given for the failure of the plaintiff to comply with the discovery rules. His sole argument was, I served it, I mailed it, it must have crossed in the mail. Now, that doesn't comply with the statute. The judge would have to find that there's some reason. It could be excusable neglect. There could be lots of things. There was nothing pled. Judge McGuire was unfamiliar with the case. This was his first, he was a motion judge on this. And his finding was simply that the documents have been received at the time of the hearing, and therefore I'm going to vacate the judgment. That's not the standard he has to comply with.
Well, basically, it sounds to me like no harm, no foul. And what is the prejudice that you articulated down below?
The prejudice at that time, and you have to go back to when this was filed, when the judge heard it, we had no discovery. This was a year and a half after the case had been filed. We were trying to get discovery, and we didn't have it. Judge McGuire had no indication in the record of any type of the quality of the case or anything that would have happened. Lots of stuff has happened since then, but had he not made this decision, the case would have been over. So the prejudice is this case should have been over at that time. We did not have discovery. The rules are very clear about what you have to do. You have to
ultimately were not prejudiced, correct?
Pardon?
You ultimately were not prejudiced because you had sufficient time and you did get the discovery.
Well, the question isn't whether we were prejudiced. Rule 33A sets forth a mechanical standard that says if you do not comply, then, and I complied with all the rules, and you file this and request a judgment, the clerk enters it. The clerk did that. Now, the burden is then on the plaintiff, on the plaintiff in this case, to show that there's some reason that they could have for the error. There was never any reason alleged for the error. The plaintiff simply ignored the rules. The judge didn't find any reason. If you were to take a standard that the judge can just say, as Your Honor said, no harm, no foul, then there's nothing no purpose of having Rule 33A in this penalty anyway.
Did
I
you
mean,
ask for any lesser relief than default?
No, I did not. I
In
complied just with.
In the alternative?
No, Your Honor. At this point in time, the judgment had entered, or a final judgment had been entered in my favor. The motion that was filed was an emergency motion to strike that. It was filed without any claim of any reason of neglect, anything at all that would excuse it. I did not request any other relief. I requested that the motion be denied.
Right. I don't want all of your time to be consumed by this. So you may want to move on to some of the documents.
Yes, Your Honor. The second relevant argument we have, both have to do with whether or not the statute of frauds applies here. Now, the statute of frauds, as you are aware, applies if it requires a written contract for a contract that has a year duration. The only evidence presented at trial was that in 4 different places cited in my brief several times, probably, the plaintiff on examination, direct examination by his counsel, 4 times said that this project was a year-long project. There was no writing. Everyone admits that.
Why does that show it was more than a year-long project?
If you read the language, he said this would take care of him for a year. This would, the court can read the quotes. It is obvious that at that time on direct examination, he was, I can't say for sure what their strategy was, but I believe he was trying to play up the fact that this was a project for him that was pivotal to him.
But was it your burden to establish that it could not have been completed within a year? Was that your burden?
I think once the plaintiff established and read the quotes, he said that it was going to be more than a year. That relieved me of any burden to establish that, because the only fact on record is what the plaintiff himself said. He's bound by what he said.
How are we supposed to evaluate what was and was not the trial evidence when we don't have, if I'm correct, the entire trial transcript in the record?
You're correct. You do not have the entire trial transcript, but you do have every quote that he made about what time, how long this project would take. That was the evidence that was there. And if you look at the judge's finding first on the directed verdict and later on the judgment notwithstanding the verdict, you would see that she believed, especially on the directed verdict, which happened at the conclusion of the trial, that the work would be done over the summer.
How do we know that that's incorrect when we don't have the trial transcript?
Because the plaintiff himself said it wouldn't have been done over the summer. He said it was.
He may have said something else. We don't know.
And the only evidence you have in front of you is what the plaintiff said. I did not include the whole transcript. You are correct.
So when you say the work was being done on a time and materials basis, does the record define what that means?
I don't know that there's anything specific in this record. It is a term of art in the construction industry. You put in a certain amount of labor and you put in a certain amount of materials, and you are paid for the labor and the materials.
I guess what I'm trying to understand is how often are you paid?
Okay, am I paid? It was the plaintiff who was doing the work on the time and materials basis.
Right, that's what I'm trying to understand, is how often would the plaintiff be paid in that situation?
The plaintiff would submit an invoice and the invoice would be paid.
How fast or slow would the invoice be paid?
Usually the invoices were monthly. He submits an invoice, we submit a requisition to an owner, and the owner pays us, and we pay them within 10 days after we get paid.
So how does that not satisfy the statute of fraud situation? Because that's not more than a year.
Well, if you're going there, and it's on a time and materials basis, then you have to find there wasn't any ongoing contract, because what they said is, in their trial said that we had a contract for this overall project. They got paid for a lot more than the work they did. What the record shows is they did $24,000 worth of time and materials. And they created a contract, which the jury upheld in that trial. But
And
it
I
wouldn't have
take
been
it
time
your
and material.
argument on, because they say, well, they made a bid and you emailed them to proceed, and that satisfies the written requirements of the statute of frauds. And I take it you would say that was not the plaintiff entity.
It wasn't the plaintiff entity. It was, and we would, have paid them. We offered to pay them the $24,000, and they refused and filed a suit against us.
The $24,000 was for the time and materials,
Correct.
but
they had if they need a contract for the rest of it. It isn't a contract for the time and materials work. They did some work.
right.
And then they were
you're saying
terminated.
the bid was for more than that, or not more than
The
that?
bid was for the whole site project, was way more. The scope of this project was a lot more than moving some dirt around.
So why does the bid and your email to proceed not satisfy the statute of frauds?
Because what we asked them to proceed with was a specific smaller scope. We needed some things moved around to begin the project. The project hadn't started at this time, but he's a site developer, and what a site developer can do, we have to have some trenches so we could see where pipes were, etc. So the project hadn't started at this time. But he came in and did that, and he volunteered to do it, and he seemed like he was good at that moment. The
clock just switched over to 15 minutes, but you had about 3 minutes left.
Yes. The other point I just like to make really quickly is this case was very confusing because there wasn't one entity involved. There were a lot of entities named Sunrise or some variation of Sunrise. The plaintiff even had to file an amendment to their complaint, switching entities. And there was also Kerosene itself, who we thought was the one doing all the work. We tried to get the trial court to say that you had to be specific about which entity it was. And the response to the trial court was simply, you can convince the jury of that. We believe that was incorrect. It created a lot of room for the jury to misinterpret things.
Was the jury instructed on that?
The jury was not instructed on that.
Did you ask for an instruction on that?
I did not ask for a specific instruction on it. The judge had ruled that that was a non-issue.
Was there a defense in the case that you contracted with an entity other than the one bringing suit?
Yes, the entity we thought we had contracted with was Joseph Kerosene LLC. And it was Joe Kerosene was the worker in there. They initially billed for the time and materials under Kerosene LLC, and then when they were terminated, they sent the new bills. Same work, new bills, but under this Sunrise equipment, and the first entity didn't even exist.
So was your theory at trial that you entered into a written contract with Kerosene LLC?
Our theory at trial was we had no written contract with anybody. We hired someone to do some scope of work, and that was Joe Kerosene LLC. Sunrise was new to us. They were all over the record, and that allowed them to expand this, willy-nilly. Anything that had to do with Kerosene, they said had to do, or Sunrise of any variation had to do with them. It created a lot of confusion at trial, and we believe that there should have been, the motion to eliminate should have been granted, and if it had been granted, the trial would have had a much different course. And there's no more questions. I don't know whether I've exceeded my time or actually finished early, but
You have you have about a half a minute left. Let me check to see if there are any questions.
and the last thing, and I know it's hard because we're people that this trial happened and all this happened in the intervening 5 years, but I urge you to look at the initial situation and say, I have to evaluate this as it was in that time of discovery. And I can't look at anything beyond that because that's what the judge should have done. Now I'm over.
We have your argument. We appreciate it. And now we'll hear from attorney, is it Hamer,
Your Honor.
Hamer.
Thank you. Good morning, and may it please the court. Robert Hamer for the plaintiff Sunrise. This is not an easy record to decipher. The offered contents of the appendix are arbitrary, disorganized, and randomly abridged. The record of trial testimony is particularly sparse, with what I count only 15 pages included. The burden is on the appellant, here CMB, to provide the court with an appendix sufficient to support each of its points on appeal. Rule 18 provides fair warning that failure to reproduce the entire transcript may result in the waiver of the issues raised.
Counsel, does he leave any evidence or testimony off on this question about how long the contract would take to perform?
I think the substance is in the testimony at pages 42 and 43 of volume 1, with a general reference made by Mr. Kersey that it was what he characterized a year-long project. It was work for us for a year. And then he goes on to say that, so when we got this job, it was big for us because I didn't have to look for work because we had enough work for a year.
So why does that satisfy his burden?
Because it doesn't show anything that the contract required more than a year to complete. If the work could be completed, the statute provides that the writing is required where the work was not to be performed within a year from the making. If it could be performed within a year and it was not bound to extend performance over a year, the statute is not applicable. So the statute is not applicable, and as raised in argument, the direct argument here, even if it was applicable, it's satisfied here anyway by the bid that was submitted, the written bid that was submitted, and the notice to proceed sent by email. Those are the same steps that were recognized as satisfying the statute of frauds in the Jacobson and Perman case, although with different technology in the 20s, cited in my brief. So the statute was satisfied even if it was applicable to these circumstances. The kind of sufficiency of the record is problematic on all the other issues that are offered or pressed by the appellant on appeal here. The contract argument is a jury question. The argument that's included in the papers recognizes that what counsel characterizes is a lot of confusing evidence. That's ambiguity. That's a question of fact for the jury to determine, and it was submitted to the jury, and the jury did make its determination of that question of fact. There's no record presented here for the court to review to assess whether or not there was any abuse of discretion in the trial judge's action on any of the motions that are challenged here. There's no challenge to any jury instruction that was given.
But don't we have a sufficient record on that, the first claim?
The first claim being
regarding the removal of the default?
There is a sufficient record on that. There's no record of any trial of the argument, the back and forth on that. But I think the highlight there is that there's no suggestion of any preference or prejudice, rather. The law provides for marked deference being given to the motion judges who are in the best position to balance competing claims of fairness and case flow efficiency. I mean, it's really kind of in the trenches, being a traffic cop and making sure that each side fairly shares evidence in order to try the case. And the case was.
So but the defendant's point is that a judgment actually entered. A default judgment actually entered.
Yes.
Did that happen?
I don't know if like the paper, the separate paper entered. I know that I've seen the docket, which indicates that judgment entered, but I haven't seen the paper as part of any record.
So what was the standard the judge was supposed to be applying?
Looking at, it's an abuse of discretion. It's the judge's discretion to face resolution of disputes upon their merits rather than the technical procedural grounds that are applicable in policing timeliness of discovery. And evidence was offered and included in the record that the interrogatory answers here were signed on November 25th, mailed on the 30th, and the application for final judgment was made on December 3rd. So it's fair in assessing those calendar entries for the judge to favor the merits of resolution and recognize that the application was prematurely filed.
Should the judge have been applying a Rule 60B standard?
I don't know that the result would be any different under that. If the answer is crossed in the mail, as the judge apparently determined based on the arguments presented, is that excusable neglect? We don't know what the record raised on that was. There's no record of the argument before the motion judge to kind of see what was in his mind at the time.
Do we know there was argument?
Pardon?
Do we know that there was argument?
I don't know that there was argument, Your Honor. I was not counsel of record at the time.
So how is it that you're pointing to what may or may not have been said during an oral argument if we don't even know whether there was oral argument? Well,
it being the appellant's obligation to prepare and present a record of sufficient to support their claim, I think it's
well,
left.
They're contending that the only thing was your motion.
Well, there's plenty within the motion in its description of the timeline for.
What did your motion explain as to why the interrogatory responses were not made earlier?
Well, there's the signing of the interrogatories on the 25th of November, and they're mailing on there's a cover letter with the mailing on the 30th of November. So, those, I point to those calendar.
Is there any explanation as to why they were so late?
I don't know that there is an explanation in the record on that, Your Honor.
So that would be hard if the standard is excusable neglect, it would be hard to meet that standard, correct?
Hard
on this record.
Well, I suppose because of the nature of the record, yes. I don't know that there is anything that addressed it. It was handled in the routine manner of managing case flow, given the principle of sharing evidence in order to try case and ensure that no party is prejudiced by one side hiding the ball from the other. This all occurred nearly 2 years prior to the trial. There's no suggestion that any prejudice resulted. And to kind of put the issues of technical discovery compliance, and I don't minimize that, but technical discovery compliance, and really here looking at the dates, it's really kind of close on the 45 days for answer and then the 40 days for the final notice, to elevate that to a level that preempts a jury verdict 2 years later, nearly 2 years later, for some $400,000 is, I think, putting form over substance. I understand the issue raised with regard to the record. I don't know that lengthy records are, in my experience, often made on this kind of discovery motion and its resolution, given the heavy bent of the application of the rules to reach fair and just decisions on merits rather than on technical procedural grounds.
So as to the question of whether the notice of appeal was timely, the defendant argues that the plaintiff did not file a Rule 59 motion, and so that affects whether their appeal was timely. What do you say to that?
I would refer to under Appeals Court Rule 4A2, Section B, that what this was with regard to the assessment of attorney's fees under 93A was really a motion to make additional findings of fact. That is, what are the reasonable attorney's fees to be assessed in connection with the judgment? So I think it kind of misses the nature of what this is, even though under 93A and an award that's to follow for unfair and deceptive trade practices, it doesn't nicely fit, or at least expressly fit within the rules of civil procedure. I think it is in the nature of a Rule 52B motion to make additional findings, that is, the reasonableness of the fees to be assessed under the circumstances. And if there are no other questions, I would rest on the brief submitted.
Let me check. I don't see any. So thank you for your argument. Thank you both for your arguments. It's been very helpful to us, and the case is an interesting case. Pandemic. Although we're conducting argument in this format, all the ordinary rules of argument apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I will call the case of Deborah Kingston versus Burlington Veterinary Clinic, case number 2019 P 1681. Attorney Matus, we're ready whenever you are.
Thank you, Your Honors. May it please the court, John Matus for Deborah Kingston. Your Honor, we're appealing the decision of the trial court in this case. This case, the crux of this issue of our appeal is the fact that we had strong evidence that was presented that one of the witnesses had doctored several photographs that were very, very important in this matter. And when this was brought to the judge's attention pre-trial, the judge, the Superior Court, did not allow the pictures to be challenged on that basis. They did not allow the calling of an expert or anything to be brought up on the metadata on the photos. By brief, sorry, Your Honor.
I just want to make sure we're being precise. My understanding, and please correct me, is that you were challenging the metadata on 2 of 3 photos.
Yes, Your Honor. Well, at least 2 or 3 photos. The question really was whether what the judge should have done, what the Superior Court should have done when presented with the evidence of spoliation. The expert in this matter, when he was allowed to view very quickly the thumb drive that contained the photographs, he had discovered on 2 of them the discrepancies that he was able to discover. And as he states in his report, which was an 11-page report that he turned out in 3 days, he would actually need to look at the computer itself that the photographs were stored on to see if there was any other metadata that he was missing before he gave, to see if the other photographs also reflected that time signature change. But in his initial look at the thumb drive that contained these photographs, he did find evidence that the actual timestamp on them was a day later, on January 24th, and not on the January 20th date. And so initially, what this was brought to the court is spoliation.
I guess one thing I'm trying to understand is that it seemed like the timestamp on the photos was after 5 o'clock on a January night.
The initial one, the one that the defendants proffered, Dr. Hansen proffered, yes, it was given at 5:06. The timestamp was 5:06 p.m. on January 20th.
And you could cross-examine her on that point.
And
pretty much anyone who lives in Massachusetts knows that in January it's dark at that time.
I would, Your Honor, honestly, I would challenge that point only to the fact that I do not believe that it's something people can take judicial notice of. I don't know that you could do a survey of people and they would all say, oh yeah, at 5:06 it's definitely completely dark. And
you had your weather expert though.
We did have the weather expert, who was the one who initially pointed this out, who said it would have been dark at 5:06 p.m. Plaintiff's counsel didn't realize it was going to be dark at that time. And when he put 2 and 2 together, and he said that
even if it's not something, even if we were to accept that it's not something that's common knowledge, your weather expert would be able to testify to the fact that it would be dark on that particular night at that particular time.
Yes, he would, Your Honor, and he did actually testify to my recollection in the transcript. However, that was not to say that the jury had to, number one, accept that, but number two, also, the jury didn't have to accept the fact that the camera was not able to take a photograph at that time. It would have needed a technical expert like we proffered, Mr. McLean, who could have stated that it would have been dark in this photograph. The timestamp is all wrong. You would not have been able to, it would not have been as bright. Dr. Hansen did testify she did not use a flash, and she testified that consistently throughout. So the jury would have concluded, had the expert allowed to testify, that that photograph was not taken at the time it was.
Well, please go.
Sorry, I want to make sure that I understand the procedural posture correctly. You raised this issue in a motion to continue the trial date. Is that correct?
Yes, that is correct, Your Honor.
We would review the denial of that for abuse of discretion. Do you agree with that?
Yes, Your Honor.
And I gather that there was, or at least the judge deemed there to also be at that hearing an oral motion to exclude the evidence.
I do not believe that was the posture, Your Honor. I believe the posture was that that the evidence could be.
You think it was just a motion to continue?
Motion to continue, and motion to allow this expert to at least testify. This was a rushed motion. The expert report had only come in the day before, and counsel was at the oral argument. Counsel stated there's a spoliation issue here, and put the court on notice. This is spoliation. This is something that the evidence was altered there. And in Massachusetts, spoliation, unlike most states, has the Superior Courts are given wide variety to correct that, far beyond most states. Most states, it's just an adverse inference. So I don't think it was, it certainly wasn't a Brandeis brief type argument here, but the argument was, there's a spoliation issue. We need to correct this, and if it requires voir dire, we wanted to. What he was asking for was a week delay in the trial, so that this rebuttal expert could be put on the stand to rebut Dr. Hansen's proffered testimony.
There
I would
were
also,
two-
sorry.
There were two components to your motion, as you see it. One was simply a motion to continue the trial date, but the second was to permit this expert to testify.
Yeah, so that was really an underlying, yes, an issue in that
And-
motion because
and,
he wasn't on the expert list.
And both of those are subject to review for abuse of discretion.
Yes, Your Honor. We do not argue anything but abuse of discretion applies here.
So I want to make sure I also understand something else. It was you or trial counsel representing your client. I don't know if you were trial counsel.
No, I was not, Your Honor.
Who introduced the photographs at trial?
No, Your Honor. Well, the issue was this. Plaintiff called all the witnesses. Defense did not call all the witnesses. Plaintiff called Dr. Hansen to the stand. Previous to this discovery of the spoliation, there had been a stipulation that these photographs were going to come in. They had been presented at a deposition a year earlier in May 2018. The defendants wanted those to come in through Dr. Hansen if she testified to, because as the defendants actually say, one of the defendants in the Levine brief, they say the photographs were particularly harmful to the plaintiff's case. They wanted those to come in. And so these were not things that that the plaintiff was going to introduce, but they were going to be introduced by the defense counsel through Dr. Hansen's testimony. And so this rebuttal witness was necessary so long as what occurred did occur, which was Dr. Hansen. They were introduced at trial. Now, obviously, defense counsel could have not introduced them, or could have said, the Superior Court could have said, okay, I don't know if this stipulation is now valid because these were
Did you
these were
ask for
challengeable.
any of those things?
I'm sorry, Your Honor?
Did the plaintiff ask for any of those remedies?
No, Your Honor. And but they would have been futile at that point because any challenge to the metadata that these had been altered was now shut down because there was no rebuttal expert. The best that he could do.
Couldn't the plaintiff have withdrawn her agreement stipulating to the admission of these exhibits?
Plaintiff could have, Your Honor, but I believe that would have been a futile gesture because the witness who had taken the photographs, and they were relevant photographs, was going to be on the stand. The stipulation, the plaintiff, Dr. Hansen would have gotten on the stand and they would have introduced it by saying, did you take pictures? Yes. Are these the pictures? Yes. What date were they taken? The timestamp states that they were taken on January 20th. I agree with that timestamp. And then it would have gotten in. It would have been a futile gesture.
But then why would it have been futile? Once you've done that, then you could have argued that it put that issue into play rather than standing by the original stipulation.
While it did put the issue into play, it did not allow plaintiff to call the rebuttal expert because, as the judge said, this is unfair. He didn't. I don't believe he used the term unfair surprise, but he was saying, look, you had months to give us this expert. You didn't give it, so he's not going to testify. We're not going to continue. We're not going to allow him to testify. So the only challenge was exactly what the plaintiff did, which was cross-examine Dr. Hansen on the timestamp. She didn't waver. Then have his weather expert testify that it would have been dark at that time. That was the best that could have happened. And that was the only thing that could have happened, whether the stipulation had been carried through, what had been agreed to or challenged. And they'd have been forced to bring it in through regular normal trial means. I'll put it that way. In the Levine brief, they do say that these photographs are particularly harmful, and this is an example where this was excusable on the plaintiff's part. This was not a document-intensive case at all. This was a slip and fall. The question was there ice on the ground at the time when the plaintiff fell, and did it cause your fall, and were the defendants negligent as a result of this? Unfortunately, to claim that the plaintiff had a duty to investigate the metadata on these photographs when there was no indication on first blush that there was anything altered about them, and when the plaintiff clearly, as the plaintiff's counsel did at trial, have counter arguments to that. The counter arguments that he made in front of the jury were simply the obvious. Number one, this was clearly taken later in the day. Number two, the ice could have been removed by another person later in the day. Number three, that the angles did not show the angle correctly under the car, which is what he argued in his closing. However, that's what a normal in a normal situation where the photographs do depict the time and date stamp that they do. That's what you do. But when an accidental discovery is made that they have been altered, that's excusable neglect. That's in a unique situation. And it's a unique situation that cries out for, he wasn't asking for months of delay. Certainly defendants could have at that point said, well, we want to depose this expert, please give us delay. And I think the court would have been amenable to that in light of giving a week. But they were only asking for a week merely because the expert, the rebuttal expert, just couldn't physically be there. And there were lots of solutions. There was already a witness, Mr. Calvecchio, who was the grounds maintenance person who was hired to clear the driveway most of the time during the winter time. He was not able to testify. He was testifying by deposition. They just read portions of his deposition into the record. So this was not even unique to this case. And it was an extraordinary situation because one of the defendants was, according to the expert witness, perpetuating a fraud on the court, a very serious fraud that
Why did he come to this fraud of the court theory? I mean, many people don't properly set the timestamp on their computers and their VCRs and their DVDs and their cameras.
I agree, Your Honor, but in her deposition testimony, Dr. Hansen did testify, and I do want to make sure that I'm saying this correctly, that she had taken it after 5 p.m. on the date in question, but she was adamant at least that she had taken it on the date in question. And the plaintiff's expert said, no, the evidence that I'm seeing states that she did not take it on the date in question, she took it the day after. And she was adamant about holding to that date. She held it on the stand and held it in deposition. So the fact that, and if she wanted to argue, I didn't set the date on my camera right because I'm not a tech person, that's an argument that she can make after they can recall her and have her make that argument and say, I don't know how to set my camera time. But even if that were, the fact that the timestamp on the photos was January 20th at 5:06 p.m. She testifies that she took it on January 20th around 5 p.m. And then later on she says, oh, I don't know how to take a timestamp. It would have caused in the jury, at least a rational jury, to say, you're claiming you don't know how to set your camera time, and yet you claimed earlier that your camera time exactly matched up to the time you took the photograph. You know, there's some kind of discrepancy here. And that would cause doubt in the jury's mind about whether these photographs actually depicted the parking lot on the date in question and the dangers in that parking lot, and whether those dangers could have contributed to her fall.
So one of the defendants argues that because the expert disclosure of Mr. McLean was not within this time standard. Do you agree with that?
Yes, Your Honor, it was late, obviously.
But they also argue that he actually did not have an admissible expert opinion. What do you say to that?
Well, Your Honor, the question isn't whether the question about whether his opinion was admissible as an expert opinion, that's debatable because we never reached that issue. He certainly states in his expert report that he wanted to look at the actual computer files, not just merely the thumb drive of the copy of the photograph, but the actual computer files to solidify his answers. And he doesn't say but he does say these two of these photographs, which are depicting the ground underneath the car, definitely show evidence that they've been tampered with and that they were not shown on the date in question. And at that point, when the Superior Court heard that, there should have been a question of maybe we need to call this witness to voir dire him, because the opposing side did not have it. I'm sorry, Your Honor?
I think we're going to have to leave it there. Your time has expired. Let me see if there are any further questions. All right, seeing none. Thank you for your argument.
Thank you, Your Honor.
Which of the co-defendants is going to argue first?
Your Honor, we agreed that I would, for the Levine Family Realty Trust, would proceed first.
Okay, we're ready whenever you are, Mr. Murphy.
Okay, again, Your Honor, my name is Tom Murphy. I represent the trustees of the Levine Family Realty Trust. May it please the court. We are asking this court to affirm the decision of the trial court. The plaintiff on his brief and on argument, in strong words, claims that there was evidence of perjury and there was evidence of fraud on the court in this case. The issue with that argument is twofold. Initially, the plaintiff never raised such an argument to the lower court to put the court on notice that there was some issue with spoliation, that there was some issue with that a witness in its court was going to perjure herself, and that there was a fraud being committed on the court. And then the second part of the second issue with the plaintiff's claim is that the expert report of Mr. McLean, which the plaintiff proffers as evidence that there was perjury, simply does not support the claim that there was perjury or fraud in the court.
But what it does support, does it not, is the contention that two critical exhibits, two of the photographs, were possibly taken at a time other than had been represented.
Respectfully, Your Honor, I don't believe the report says that. I believe the report says that two of the three photographs which were examined by Mr. McLean, and it's important to note that these are digital files that the plaintiff's trial counsel sent to Mr. McLean in email, that two of those photographs have metadata which he questions. He doesn't say in his report that the metadata was tampered with, that it was altered, that it was changed in any way by the proponent of the evidence, Dr. Hansen. He merely says he's questioning the metadata on these two digital files that were sent to him by plaintiff's counsel, which are not the original evidence, which is not what Dr. Hansen took from the camera and put on the computer, her computer, not the evidence from her computer that was propounded in the case. So,
did you ever produce the actual image from her camera?
Your Honor, I did not represent Dr. Hansen, so I never had access to the original file.
Was the original file produced in discovery?
I cannot answer that. I'm not sure. My understanding is that the files were put onto a USB stick and they were handed over to the plaintiff during the course of discovery. I don't know what constitutes an original file for the purposes of what Mr. McLean is referring to in his expert report. And that's part of
I'm sorry, you would agree that it appears the sole basis upon which the judge denied the motion to continue was the fact that this came up late?
I would agree, Your Honor. I would agree. And I think the judge was well within his discretion to do so, because when you look at the timing of this expert disclosure, when it happened 10 days or less than 2 weeks before trial, and you have a new line of expert testimony, and the plaintiff is saying, well, give us 1 more week so we can testify. Well, the issue with that is the defendants have not been put on notice as to this new line of testimony.
Sure, but I want you to pause. I have a couple questions on the same line here. The first is, do you have a case that applies this late disclosure analysis? You can exclude expert testimony when it's been disclosed late, where the expert is going to testify to, and I don't want to use spoliation as a magic word, let's just say some question as to whether a document has been tampered with.
I am not aware of the case with that specific fact pattern, Your Honor, but I would also, in fairness to the trial judge in this case, the trial judge was not put on notice that the allegation was being made that there was a fraud on the court about to happen in this court. And I should also note that this motion to continue was made on July 2nd. The trial did not start until July 10th. the photographs didn't go into evidence until July 10th. The plaintiff had at least 8 days between the denial of the motion to continue and when the photographs went into evidence for the jury to take the time and bring this to the attention of the trial court, to let the court know that perjury was supposedly about to happen in its court, or that fraud was going.
Maybe I'm misreading the hearing transcript, but I see that the judge invited essentially an oral motion to exclude from the defendants and ruled upon it.
I agree, Your Honor.
So,
That's my reading of the transcript as well.
So you're saying that even despite that, the plaintiff had an obligation to go back and try again?
Well, I'm saying the plaintiff had an obligation to bring this supposed perjury and fraud on the court to the court's attention beyond a motion to continue, whether it be a preliminary hearing on spoliation to allow the defendant to respond to the claims, whether it be some type of voir dire while the expert was still available before trial, whether it be some type of action to object to the introduction of the photographs into evidence. But there were many, so in the plaintiff, an argument is claiming that the judge had numerous options to prevent this spoliation and this fraud from happening, but the plaintiff also had numerous options which were not taken.
Let's say we were to agree, we were to decide that the judge abused his discretion in denying the motion to continue based on the material that was submitted. In your view, what would be the appropriate relief?
I'm not sure, Your Honor, because it would seem to me that the judge would have to allow the defendants to respond to this late expert who does not have an opinion, and the defendant should have the opportunity to determine whether this expert is even qualified or whether or not the expert has the ability to testify what he's claiming in his report.
All right, so let me see if there are any other questions.
No.
All right, thank you. Attorney Austin.
Thank you, Your Honor. May it please the court, again, this is Tanya Austin representing Burlington Veterinary Clinic. I would posit that following up to Attorney Murphy's argument, the plaintiff's sole argument here, and in fact, she characterizes this sole argument in her brief, is that there was strong evidence that certain photographs had been altered, and that there had been spoliation, and that Judge Wall had improperly refused to admit evidence on that issue. And the question is what the judge should have done in light of the evidence of spoliation. And I would again follow up saying, I think we all dispute this, because the sole thing they're relying on is Mr. McLean's expert report, which explicitly says that without examining all the original digital evidence in this matter and not knowing the detailed picture of file actions and process and tools used, it prevents me from reaching an expert conclusion about the digital photos and their metadata being modified. So he explicitly declined to make any sort of conclusion as to whether there had been modification. And given that, I would say this report is essentially no more than speculation. He explicitly does not have the underlying relevant facts necessary to make any expert opinion.
Well,
so
I don't know that I would call this speculation. Why is the appropriate response not for the judge to have allowed the motion to continue in order to explore all of these issues that you and the co-defendant raise as to what exactly this report means?
Yeah, I would say that goes back to the late disclosure, because it's undisputed the plaintiffs had those photographs in their possession for over a year before they even thought to look and compare the timestamp versus the lighting in the photographs. And during that period of time when discovery was still open, it would have been easy. And in fact, it would have been warranted for them to look and try to verify the time data. Now, while counsel just argued that it's not incumbent upon them to look at that, the discovery rules, and they're recently modified, require metadata and electronic things to be provided as part of the data in the discovery. And it's for just that kind of reason, so that plaintiffs can, if they feel it appropriate, if they take the time to do it, go inspect that and see whether the metadata provided supports, what's supposedly representing. And here, the plaintiff, for whatever reason, failed to do that.
Counsel, are you saying that the metadata was provided during discovery?
Your Honor, I wasn't trial counsel, nor did I litigate this case. I am, as my brother, unaware of exactly what data was provided. My understanding, as he said, was that the photographs were put onto a USB stick and provided in that way to plaintiff's counsel. So I cannot answer that specifically. But again, if plaintiffs had felt the data provided was insufficient in any way, they certainly would have been within their rights to request that access to the original computer even to see exactly what that metadata was. And again, they failed to do that. They had the photos for over a year. And even once they noticed there was an issue in April 2019, by their own admission, they waited another 2 months before retaining an expert to actually, render an opinion, which again, I don't think he ever actually did. His expert report is not an opinion. It explicitly states there is no opinion about whether those data were modified in any way. And the court even noted at the hearing that had the plaintiff brought this to the courts and the party's attention in April 2019, when, as she said, she first noticed this potential discrepancy, the result might have been different. But the plaintiff simply didn't do that. She retained an expert, went to the trial conference the following day and didn't tell anybody she retained that expert, and then waited until 3 more days after the trial conference before bringing this emergency motion to continue. Notably, the plaintiff never even supplied Mr. McLean's CV or any summary of his expected testimony, in clear violation of their obligations under Mass Rule 26. The rule requires seasonable updating of expert reports and disclosures, and that never occurred here, not even in the context of the emergency motion to continue. So while counsel is characterizing this as a failure to admit evidence of spoliation, and that continuance would have been essentially a minimal inconvenience to the defendants, the fact remains that continuance was never even demonstrated to be warranted. And if you look, I would note, Your Honor, you had previously asked as to whether there'd been any case law about whether striking an expert testimony was appropriate in the context of spoliation or potential fraud upon the court. I would agree. I don't have a case on that point exactly, but in our brief, we referenced the fact the Atlas Tack case, in which the court was allowed, the appellate court upheld the trial court striking of expert testimony, even when it explicitly resulted in summary judgment for the opposing side. So when it's clear that even though the expert testimony was crucial
it seems to me there's a real difference. It's not supposed to be the party receiving discoveries obligation to also not only conduct discovery into the merits of the case and the claims and the defenses, but also into whether or not there has been spoliation or tampering of evidence. That seems to me the timing of that, it really doesn't lie in that party's control in the same way that it does with respect to other experts.
Fair enough. I would go on to say that, again, if you look at McLean's testimony, or not testimony, the report, because again, there was no expected testimony, there was no summary of what he was going to say. As noted, I don't believe it would have been admissible in this case. And again, when you asked my brother counsel what he would have suggested the court do, if it turns there was not an abuse, that there was an abuse of discretion, I think the issue here is that requiring or permitting a continuance of the trial or permitting Mr. McLean to testify would have opened up the door to essentially an entirely new course of discovery. It would have required Mr. McLean to actually been provided with this metadata and do an opinion, and it would have required, I would say fairness would require that the defendants be given an opportunity to depose him, retain their own expert, who would then have also had to be deposed. All of these things are supposed to go on during discovery.
That's what you think would need to happen were we to conclude there was an abuse of discretion here.
I agree. I think that's what would have had to happen in order to have fairness for both sides.
I'm talking about on remand. If we were to remand, you would think essentially there would need to be a do-over with both sides entitled to explore what the significance, if any, of this information was.
Yes, I think there would, because in order to allow Mr. McLean to testify, in order to remedy the unfairness that would result from just springing this on the defendants without any chance to depose him or get their own expert, it would be inequitable. So you would have to reopen discovery and have an entirely new trial after all of that new discovery had been conducted. I think that's honestly, I think that would be an unreasonable result. I think that given the abuse of discretion standard and the fact that trial judges have broad discretion to exclude experts and to deny motion to continue, we're talking about, the LL versus Commonwealth case that both of a defendant cited. So the judge has to make a clear error of judgment. Decision has to fall outside the range of reasonable alternatives. And in this case, what happened in the trial in this, where Mr. McLean's testimony was not permitted, the trial went forward as had been scheduled for months. That is a reasonable result of the plaintiff's own essential failure to follow up on discovery and make sure that common sense reigned here. I would direct your honor, as you point out, when it gets to be 5 o'clock outside, I'm going to look outside my windows. It's January in Massachusetts. It's going to be dark. It is going to be clear that just looking at what time it gets dark in New England, it's apparent, and that discrepancy would have been obvious to anyone looking at it. It's not something that they could only have discovered 2 weeks before trial.
But I'm not sure that one would discover that it meant the photo was taken the day after as opposed to earlier in the day.
Well, the question then is, if the only question is the day after, then why are they saying it was 5 o'clock the day after, in which case it would still have been dark? If the whole issue is they recognize that the timing of the photograph was the issue that prompted them to get an expert, I would not, and since the expert again has not said what day those photographs were taken, and is only talking about 2 of the 3 photographs, which all depict the same light levels, the same location, and were taken apparently, he's saying on 2 different days. There's no reason why one of those photographs would be valid and 2 of them wouldn't, and that the times would be different in the way that his expert apparently is trying to say without actually making the opinion that's the case.
All right, thank you. We have your arguments. Thank you.
Thank you, Your Honor.
You're live and recording.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting argument in this way, all the ordinary rules of procedure apply, including that each side gets 15 minutes to argue with no rebuttal. And with that, I'm going to call the case of HEIDI HACHE versus Wachusett Mountain Ski Area, Inc., case number 2020 P0455. We are ready whenever you are, Attorney Raphaelson.
Thank you very much, Your Honors. This appeal involves a near classic case of fraud on the court. Wachusett engaged in a pattern of intentional conduct designed to hide the fact that its lift attendant, Dylan Wilson, was not properly trained when Alex HACHE misloaded the Polar Express lift. There's no genuine dispute that the Shepard training record was falsified to show that Wilson and not Shepard received the training before Alex fell. Wachusett essentially admits it, or admitted it in the oral argument on the motion in the trial court. Counsel said, we don't dispute the fact that it appeared that documents were changed after the fact. The motion judge referred to those documents as the forged training records. There's clear and convincing evidence that there was a falsification of a training record intended to show that the base lift attendant had the training that he did not have. Wachusett's argument boils down to a claim that Corey Feely was a low-level employee who did not act on behalf of the corporation when he falsified that record and when he testified under oath as to its authenticity.
So, counsel, is there any evidence in the record from Feely or anyone else that someone told Feely to forge the training records?
No.
And I understand that the defendant responded to discovery requests for any documents and ESI relative to the identity of Jay Shepard, et cetera, and that their response was that there were no such documents in Wachusett's present care, custody, or control. Was there any discovery about how that is at all conceivable?
Yes.
And what does the record show on that point?
Yes, Judge. And that's a very significant point. And I say that, so first of all, just to step back so we're all on the same page, the request for the Shepard records were made in connection with the 30B6 deposition. In advance of that deposition, and Wachusett said that they didn't have any Shepard employment records. 6 weeks after Corey Feely testified as the designee, the corporate designee in the 30B6 deposition, as to the authenticity of the falsified record, and he gave this fictitious account about Shepard not rejecting Shepard rejecting Wachusett's offer of employment, which caused him then to repurpose Shepard's training account for Wilson. That's how Feely testified as the 30B6 deponent in that deposition. And 6 weeks after that deposition, we located Shepard, and Shepard.
But counsel, I understand that, and you did a great job, but there's no jury here, and we are drilling down on the Wachusett's part of this. And
Yes.
That's where I really need you to focus, because I get all the rest of that was terrible, but is not helpful for resolving your appeal. And what I want to understand is is there anything in the record that explains how Wachusett's had no employment records? Because I think you make a fair point that Feely would not have been in control of payroll, HR, etc.
Yes. No, there is no way for that. There is no explanation for their failure to disclose those records. And in addition to the different departments it comes from, they had a statutory and regulatory duty to maintain those employment records. So there's no explanation in the record. There's no evidence in the record appendix to explain it, and they didn't say a word about it in their appeal.
Did you try to take further discovery on this issue?
I did not. I was satisfied, Your Honor, that when Shepard produced the records, when he produced his W-2 form from Wachusett, when he produced his bank records that evidenced Wachusett's deposits into his bank account, direct deposits into his bank account, when he produced the electronic communications with Wachusett about his employment schedule, that was sufficient. That was sufficient evidence to show that, and I specifically asked for the records. I don't know what more I could have done. I guess I could have tried to depose individual representatives of Wachusett who are involved in these different departments and had them testify about the lack of records or the presence of records. But I asked that in connection with the 30B6 deposition directly from the company. And the company said, we don't have any. And then the company went out and lied about it, because Feely's testimony is the company's testimony under the 30B6 rules.
I want to understand the timing, if I may, of the motion or the ruling that you're asking us to review. When was the motion made? It's a post-trial motion, am I correct?
Well, it was first a pretrial motion. So
are you appealing the pretrial motion?
I brought the pretrial motion into a post. It was packaged into the post-trial motion.
Okay, well, I just want to be clear here, because in my view, if you're appealing the pretrial motion, then if we were to agree with you, it seems to me you lose your jury verdict.
Well, I'm not sure that I understand that.
Because if the error you're appealing is an error that was made before trial, then it seems to me we need to undo the trial. But that's not what you want, correct?
No.
As an outcome from this appeal.
Absolutely.
So then, right. So then it appears to me that the only thing before us is a post-trial motion seeking particular relief, which is an increase in the statutory rate of interest and attorney's fees with respect to filing the motion, essentially.
Yes, Your Honor. I mean, it's true that what I am seeking is a remedy to punish Wachusett for its litigation misconduct. And that remedy—
It's essentially a motion for sanctions.
Exactly.
And so when we review that for abuse of discretion?
No, Your Honor. No, I don't believe you do.
All right, we need a case. What is your legal authority for the standard of review on a motion for sanctions?
Well, it's a motion for fraud on the court. So it's a motion for fraud on the court, and that motion, according to McDonald and McDonald versus McDonald, can be brought at any time.
Sure,
And-
but you see, there are two pieces to it. One is, even if we agree with you that there were fraud on the court, let's just assume we were to agree on that. The remedy piece of it is discretionary. And
Absolutely.
that part is to be reviewed for abuse of discretion.
In this case, however, the judge didn't find that there was a fraud in the court. And so that she never got to the remedy stage for which you would then determine on an abuse of discretion standard whether it was appropriate. And the court and the cases, the Munshami case in particular, Munshani case in particular, draws a distinction between the finding of fraud on the court and the remedy. And the remedy is abuse of discretion standard. The finding is an analysis of the facts, an application of the law, and there's a footnote 4 that specifically says that it's a ruling of law, and rulings of law generally are decided on a de novo standard. And in addition to that, Your Honor.
So then if we were to agree with that it was an error not to find fraud on the court, then
Yes.
the remedy would be to remand for the judge to exercise discretion as to the remedy.
I would argue that you have that the
We need
document
to
is
have
a
some
document.
authority. Do you have any authority for the proposition that the appeals court ever decides discretionary matters in the first instance?
I have not cited that authority, Your Honor.
Right. So
I've not cited that authority.
I have a question about the record, because we don't have the trial record. What was the demand that your client made to the jury, the damages for damages? What was the dollar amount of that demand?
$4 million to $6 million. It was a range of between $4 million and $6 million. And the defendant suggested $700,000.
And this was all based on the injuries?
Absolutely. Absolutely. There was substantial evidence, unrebutted evidence of a severe brain injury, among other things, among serious orthopedic injuries. That's fundamentally.
I don't want to, Judge Wolohojian, do you have more questions on this line?
No.
Okay. So you seem to be arguing the jury's verdict might have been higher had the evidence of fraud been admitted. Could you explain how that would be proper?
Well, I'm just making a real world argument, Your Honor. I mean, jurors, in this case, there was no finding of fraud in the court before the trial, and there was no instruction that the judge gave to the jury that was unfavorable to Wachusett about that. Rather, what Wachusett got to do was to say that we voluntarily admitted liability, and we're a good citizen, and we have just a reasonable disagreement with the plaintiff about the value of the damages.
So I'm going to take you back to where Judge Wolohojian was earlier. Do you want us to undo this jury verdict?
Absolutely not, Your Honor, and I'm not asking.
Okay.
I'm not asking you to do that. This is.
It sounds sometimes like you are.
Well, but this is a matter that's clearly collateral to the judgment. The judgment stands. It's a final judgment under the cases that I've cited in my brief, and this is a collateral matter, just like 231-6F is a collateral matter. This is a motion for fraud on the court, trying to enforce and hold accountable Wachusett, because it was not held accountable in the trial. There was no finding of fraud in the court. There was no penalty. There was no assessment of costs and expenses. They have swept under the rug their wrongful conduct, and I'm trying to enforce it, and that's all I'm trying to do.
Normally we would not try a question of fraud on the court to a jury, would we?
Well, it's not an independent cause of action. And so,
right. So I'm not quite sure what you mean when you say it wasn't part of the trial. It normally shouldn't have been part of the trial.
Well, I don't know. I would have expected if the court found fraud on the court if the court actually issued a finding of fraud of the court, then I would have expected some kind of instruction relating to that from the trial judge to the jury. And the jury would have had context for why it was that Wachusett was not defending itself on liability. Instead, what the jury had was, we're good guys. We admitted liability, and we're just.
Was the claim for compensatory damages?
I'm sorry.
Was the claim at trial?
Yes.
Was the claim at trial for compensatory damages? So how would any of this factor into compensatory damages?
I think that all I'm saying is that it doesn't, Your Honor. It doesn't factor into compensatory damages. All I'm saying is that when a defendant admits liability, typically there's some context given to that admission. And in this case, there was no context. Wachusett argued essentially that they were a good corporate citizen, and that in the real world has consequences. But I think that this is about the post-trial motion. It's about a fraud in the court motion and sanctions that accompany that in order to hold Wachusett accountable for what it did before the judgment entered. Costs and attorney's fees and a finding of fraud in the court are baseline, very standard determinations that are made once a finding of fraud in the court is given. And perhaps you're right. Maybe it has to be remanded. I would like to take a look at, see whether or not there is some authority for the court.
Your final answer is that you do not want us to overturn this jury verdict.
Absolutely not. And I've never asked that.
So, all right.
That's that. This is a collateral.
I know the question though was, is that a consequence of points you have made? And we want to be clear about what you're asking.
Yeah,
so
it really isn't.
I understand. So the defendant argues that your request under Chapter 231, Section 6F is not properly before us, that should have gone to the single justice. What do you say to that?
And I'm not asking you to address that. All I'm suggesting is that the court has, if the court has the ability as a matter of first instance to decide the remedy, then one of the remedies that the court has authority to decide is to issue a monetary sanction. And I cited Goya Foods for that proposition, and I cited the reasonable rate of interest that exists under this very kind of conduct. 231-6F, the legislature, it says, under those kind of circumstances, when you file a frivolous claim or you defend against a frivolous claim, then this is an appropriate measure of damages. And this is comparable. This is an analogous situation where they've committed a fraud on the court. And my recommendation, therefore, is a monetary sanction in the same amount that the legislature thought was fair under comparable circumstances.
Since you're asking us to impose an increase in the statutory rate of interest as a, quote, reasonable sanction ourselves, what is the monetary value of the difference in this case?
What would that number be? I'm not sure. I haven't looked at that recently. I suspect it's more than $500,000.
Okay, let me see if there are any other questions. No, thank you very much. We have your argument.
Thank you.
Attorney McDonough.
Thank you, Your Honor, and may it please the court. Miles McDonough for Wachusett. Your Honors, I'd like to start with the jurisdictional issue. The Munshani case of this court, 60 Mass Appeals Court, specifically at page 719, holds clearly that when a fraud on the court issue is raised, where the fraud on the court was purported fraud on the court was discovered or discoverable prior to trial, those issues are not collateral. It's quite explicit on page 719. The court states pretrial discovery, states Munshani's conduct as well as the falsified documents were not collateral to the state court proceeding. Pretrial discovery, in our view, is not collateral when part of substantial litigation. So the appropriate disposition, I would submit, Your Honors, as to the appeal should be dismissal for lack of jurisdiction. And the non-collateral, nature.
And that's because he did not appeal from the judgment?
Precisely, Your Honor. The merits judgment. Because it is not a collateral matter, it falls under the regular avenue under Rule 4. The appeal has to be brought upon the merits judgment. And the plaintiff's own brief at pages 40 and 48, as well as page 205 of volume 1 in the index, Your Honors, which is a filing by the plaintiff below, all effectively concede the non-collateral nature of the arguments that he's raising, because they refer to the court's rulings associated with the fraud on the court issue as entailing his request for denial of pretrial and trial relief. And there's also a passage, I believe, in the plaintiff's briefing, maybe in the appendix, but there's even a concession that the judge's rulings may have affected the judgment. So the plaintiff can't have it both ways, appropriately acknowledging the nexus between the fraud in the court rulings and the judgment, and at the same time denying it so as to argue that it's just collateral. So the appropriate disposition is dismissal for lack of jurisdiction. And this is to be contrasted with the analogies the plaintiff was trying to rely upon with regard to 231(6)(f) and also the prevailing party attorney's fees cases. Of their very nature, for a prevailing party to seek attorney's fees under whatever statute, there has to be a prevailing party. There has to have been a trial. Plus, the issues in those cases involve experience of counsel, how much time was taken, et cetera, totally unrelated to the merits. So those are true collateral circumstances. And 231(6)(f) by statute says you have to have a judgment or a judgment in order to even proceed on that matter. So by statute, that's a collateral proceeding. Those are valid collateral proceedings. This case does not present one, does not present a collateral issue. So there's no jurisdiction. I want to just dispose of a bit of a red herring in the plaintiff's brief or reply brief. There's a footnote concerning Rule 59, where the suggestion is that Rule 59 might provide her some alternative relief. It doesn't, because number one, the plaintiff adamantly insists repeatedly that she never filed a Rule 59 motion, either for new trial or amendment of judgment. Number two, the motions don't seek such relief, and under Rule 7b to even qualify, they would have to do that. And also, obviously, a motion in limine could never be a post-trial motion under Rule 59. There is a procedural, turning from jurisdiction around, there's a procedural problem that I submit the plaintiff has, because as one of your honors pointed out, there's been no trial transcript provided. The trial judge at volume 2, page 429 in the record appendix was adamant that she was considering not only the written materials that plaintiff's counsel filed, but also the trial. She was mindful of what she saw, what she heard, the exhibits, the testimony, which included, by the way, testimony of Mr. Feely, whose name, and Your Honor, Mr. Feely testified, we know that, even though we don't have the trial record provided by the plaintiff. At volume 2, page 4, the plaintiff does acknowledge that Mr. Feely testified. And therefore, the trial judge, as trial judges always do, they get impressions, they observe witnesses. At minimum, Mr. Feely would have been observed by the trial judge and would have informed her at minimum as to the question of whether he came across, whether he committed fraud of any nature whatsoever or not. Whether he came across as someone who Mr. Crowley, the president, might have reasonably relied upon, as one would expect he might, because he's an employee. But the point is, the judge is eyeballing that witness, and that is relevant to the fraud on the court determination the judge is ultimately called upon to engage in.
Did you make that determination after the trial?
She did.
So what I don't understand is, given the interrogatory answer or the document request answer that Wachusett does not have employment records for Jay Shepard, how can we, that seems then that there was that the finding that Wachusett wasn't involved in the fraud is clearly erroneous, or at least can't be supported. It's inconceivable that this employer does not have these employment records unless it somehow did something very bad.
Your Honor, first let me point out that, and again, the record, volume 2, pages 418 and 419, the judge repeatedly requested if plaintiff counsel put out the question of whether or not there should be an evidentiary hearing, and plaintiff's counsel deliberately refrained from that, essentially relying upon the 30B6 argument raised in the brief, and I'll try to get to that in a moment. But what we're talking about here, and I think the judge got it right, if we consider, we look at the case law that the plaintiff is relying upon, the Rockdale case, the Munshani case, the HEIDI case, if I'm pronouncing it correctly, those cases all get down to the core question of whether it's the party. There's a party requirement here for fraud on the court. It's a narrow, stringent doctrine. And in all of those cases where a corporate entity was involved, it was the president who engaged in forgery or perjury or what have you.
But that doesn't seem to me to articulate a legal standard for, like, a legal requirement for fraud on the court. It seems to me fact dependent. And to be frank, it seems extremely important to me that part of this evidence came out during a 30B6 deposition when the witness was designated as the corporate representative.
Your Honor, let me respond. I'm sorry. Let me respond to that. The effect of 30B6 binding testimony would have been, had liability gone to trial, had there not been a concession to liability under Rule 16, would have been that the defendant would have been bound to what Mr. Feely said, not to fraud on the court. It's apples and oranges. The plaintiff then, had liability been tried, would have had its remedy by putting in countervailing evidence, which it never had to even engage in because it got directly to damages because of the way that the defense counsel managed the issue, avoiding prejudice to everyone.
Do you agree that the determination of whether something constitutes fraud on the court is a question of law, or do you see it as a question of fact?
Oh, no.
A mixed question of law and fact. And what is the standard of review?
The standard of, thank you, Your Honor. It is a question of fact. The plaintiff's brief, I think, misconstrues cases. All cases involve at some point legal questions after the facts are established.
So here, do you have a case that tells us what you've just said?
As to standard of review, Your Honor?
That it's a question of fact, subject to, I guess, then we would review.
I think I would suggest to you, Your Honor, that the progenitors, if you will, of the Buster case and the Judge Rotenberg case and all that, we've given you a number of cases on standard of review in the briefs. If you drill down on those, or I could give you at least one or two quick cites, the first Pennsylvania case, 395 Mass at 629, these are cases on standard of review, and they suggest that appellate courts, should not get into de novo fact finding.
Are those fraud on the court cases?
Those are standard of review cases. No, Your Honor, I want to tie them together with the fraud on the court concept.
Yeah. Do we have any fraud on do you have any case, a fraud on the court case that tells us what the standard of review is?
Munshani, I believe, among other cases, refers to abuse of discretion. There's not a case that I've been able to find that would say a standard of review on a case involving determination of whether somebody committed some sort of fraud would ever be other than what you would expect, which would be a clearly erroneous standard, because the judge is in the best position. This court is not in the same position as the trial judge, because the judge had to deal with, among other things, determining the credibility of counsel along with WACHUSETT. This judge grilled counsel for both sides to get to the bottom of what she could get to in making her determination. She saw that counsel had its counsel's and the defense's conduct was proactive, and they were very transparent in terms of trying to deal with this problem in a way that was fair, perhaps more than fair, to the defense in light of the comparative negligence defense. I mean, to the plaintiff in light of the comparative negligence defense. But she had to deal with, among other issues, an issue as to whether or not there was a sentient, calculated calculated scheme. And she had, we have now in the briefing, the reply brief of the plaintiff says at page 15 that that Mr. Feely's statement was plausible. Well, if that was about the nature of about the document concerning training, well, if it was plausible at any time, then clearly the trial judge, or rather, it could have been plausible to Mr. Crowley.
Counsel, I'm still. How is it that Wachusett did not have these employment records? I mean, first of all, do you agree that by law it should have had the records?
Your Honor, I don't know that. I know what the discovery responses were, okay? And I also know that the president of the company, Mr. Crowley, was relying upon Feely, who was the most knowledgeable person concerning training, and other people, whoever they were.
Talking about training. Okay, first, do you agree with your learned colleague that there was a lawful obligation for Wachusett to have these employment records for Shepard?
There was some requirements for maintenance of records, Your Honor. I'm not saying that they wouldn't have had.
And you agree that Feely, who's training people on how to use the ski lift, was not in HR with these records?
I missed part of what you said, Your Honor, but I think I got the gist of it. The answer is that he was focused on training. There were other people associated with HR. They were employees. They are not Mr. Crowley. And whoever, given that Mr. Feely was the 30B6 deponent, for all we know, he may well have been active in the gathering of all sorts of documents running around from one office to another. We don't know because the plaintiff declined an evidentiary hearing to explore those kinds of.
What's the record site for the plaintiff declining the evidentiary hearing?
I'm sorry?
What's the record site for the plaintiff?
Volume 2, pages 418 and 419, and there may be a third one after that, Your Honor. But my point is that there's a party requirement. The cases are clear that it's not even perjury by an employee does not constitute fraud on the court. So the purported perjury by Mr. Feely or anyone else, any sort of skullduggery by any employee or manipulation of documents, whatever, it does not constitute fraud on the court. The Wojcicki case at pages 210 and 211 says that, 411 Mass at 210 and 211. And as I say, the party is the key element here in terms of who has to be looked at. And the party here was the president. See the Rockdale, Munshani, and HEIDI cases. And anytime a trial judge is involved in credibility determinations, credibility of a party and its counsel, and also had to determine whatever she could in terms of the credibility of Feely from the opportunity she had to look at him and eyeball him during the trial, which we unfortunately don't have the transcript for. All of that indicates a standard of review associated with who's in the best position, a deferential standard of review. Also, with regard to the bases, and there were a number of them for the judge. Oh, if that were reduced, if fraud on the court were expanded, the way the plaintiff suggests, then Rule 60B3 would be gutted. The 1-year limitation from discovery of fraud on the court to bring it forward to the judge when discovered after judgment would evaporate. And I commend to Your Honor's the Fox case out of the Fourth Circuit that's cited in one of the plaintiff's briefs on that. It's a very good discussion of it. Your Honors, I see my time has lapsed. We'll otherwise rely upon the briefing unless there are any questions I can address to the court.
Now let me check. I don't see any. Thank you very much. Thank you both for your argument in this interesting case. Your arguments have been helpful to us. We appreciate it.